Hello and welcome to our webinar on confidentiality. Practical stuff first, you'll need to have the accompanying slides to this webinar and you should be able to access them and download them from our webinar page. As employees have spent over a year at home, we've seen a recent uptake in confidentiality issues hitting our desk, and we thought that now was the perfect opportunity to provide a reminder about confidentiality and the kind of things that can be protected. I'm delighted to be co-presenting this webinar with Charlotte. She's hugely experienced and someone that I've been fortunate enough to work with several times. She spends her days advising on varying different employment law issues, but like me, she's often involved in those cases which involve confidential information, the ways to protect it and the ways of getting it back when it's been wrongly taken. It isn't just me who thinks she's excellent, the legal directories think so too. She's a highly ranked barrister and one who's described as exceptional, technically brilliant, and my personal favourite one, and one that I can vouch for, is that she's a real star. So we're really lucky to have her with us today. Welcome, Charlotte.
Thanks, Katie. It's a pleasure to join you today for this webinar. I'm sure many of you watching will already know Katie, but for those who don't, she's a legal director in the Doyle Clayton team. Katie advises on the whole range of employment issues, but she's particularly sought out for her expertise in employee competition work, including cases involving confidential information. She's recognised by the legal directories as a rising star, with Chambers and Partners describing her as standout, really on top of employee competition work, and most importantly, a real pleasure to deal with.
Thanks, Lottie. So I'll move on to giving you a bit of an outline as to the structure of today's webinar. So we're going to start off by explaining the kind of information that can be protected. Then we're going to move on to contractual confidentiality obligations. Then we're going to have a discussion about the kind of things that can be done if there's been a breach of confidentiality. Then we'll move on to the practical steps that can be taken to protect confidential information. We then have a short chat about the kind of defences we tend to see when employees have breached confidentiality, and then we'll finish with some combined war stories that Lottie and I have both seen in our practice. So I will kick things off. So many companies consider their key assets to be information and knowledge. The kind of things I'm talking about are secret recipes, formula, list of key business contacts and customers. Some information is so important to these companies, it's not going to be a shock for me to say that they go to great lengths to protect it. Other companies have a much more laid-back approach to their information until, that is, an employee or ex-employee takes or misuses it. As important information is used by companies in everyday business, it's necessary for its employees to have access to it. It's simply not workable for employers to keep confidential information under lock and key. So, what options do employers have to prevent their employees or their ex-employees making use of information either for themselves or for a third party, such as a new employer, commonly a competitor? There are 4 kinds of business information categories that have been identified over the last 100 years or so in case law. These 4 categories govern the way that information can be protected and also the options that are available if it's taken or if it's misused. The 4 categories are: number 1, public information; number 2, trade secrets; number 3, confidential information; and number 4, information that amounts to skill and knowledge of the employee. I'm going to take public information first. This type of information can't be protected. As the name suggests, this is information that is or should be rightfully in the public domain. Trade secrets. This is the category that can be protected both during and after employment. Confidential information. This category means that employees must not disclose it during their employment. Usually, cases involve employers trying to elevate information in this category to the category above, to the trade secret category, so that it can be protected both during and after employment. And the 4th category is information that amounts to skill and knowledge of the employee. This type of information belongs to the employee and can be used as the employee wishes. Strangely enough, this is the category I get asked about most often. And the best way I can answer this tends to be through the example of fried chicken. Simply knowing how to make fried chicken is information that is likely to amount to an employee's skill and knowledge. However, if they've worked in a specialist or fast food chain, for example, that makes a certain kind of fried chicken using a special blend of herbs and spices, that blend of herbs and spices is something which is likely to either be confidential or a trade secret. So simply knowing how to make the fried chicken will be in the 4th category, but the way it's made or the recipe is likely to be in category B or C. So in employment contracts, it's usual for there to be a definition of the type of things that an employer deems to be confidential. Just defining information as confidential, however, is unlikely enough to make it protectable. Now, the leading case on confidentiality is over 30 years old, and it's called Facenda Chicken versus Fowler. Again, I apologise that I'm sticking to a chicken theme here, relating on from my fried chicken example and the fact that the defendant in this case is called Fowler. A little bit of background on this case. Facenda bred, slaughtered and sold chickens. Mr. Fowler was employed as their sales manager. Mr. Fowler was arrested and charged with the theft of 45 chickens, and he then later resigned. The following year, he set up his own business. Now, his own business also sold fresh chickens, and these were sold from refrigerated vans. His new business venture competed with Facenda, and some of his new customers were former customers of Facenda. Mr. Fowler also recruited some of his former colleagues to join him at his new business as well. Facenda brought a claim against Mr. Fowler and his colleagues, alleging that they'd breached their contracts of employment by using confidential sales information relating to the requirements of customers and the prices that they paid. Importantly, Mr. Fowler and his colleagues had not signed contracts which contained express confidentiality restrictions. So the question for the High Court was whether such restrictions should be implied into their contracts and whether they'd breached those implied terms. Ultimately, the court dismissed Facenda's claims. They found that while the individuals had used sales information that they'd obtained during their employment, that didn't involve a breach of their contract. While the information was commercially sensitive, it wasn't truly speaking a trade secret. Facenda did appeal to the Court of Appeal, but were not successful. The important thing from this case is that the court identified 2 types of information the law was concerned to protect. Now, the first is trade secrets, and where information is a true trade secret, it is protected by an implied duty of confidentiality, even after the employment has terminated, and mere confidential information. Now, employees must treat this category as confidential during their employment, either because they're told it's confidential, or if not, because it's obvious that it's confidential. And for so long as their employment continues, employees may only use this information in the best interest of their employer, but they mustn't use it after they leave.
Thanks, Katie. I'm going to step in now and talk about the different contractual obligations that might exist relating to confidential information. And there can be a number of different types of contractual obligations that may be at play in any different case, both express terms which are actually written into the contract and terms which are implied by law, which Katie mentioned in relation to Facenda Chicken a moment ago. And in any case where you're looking at potential misuse of confidential information, it's important to identify right at the start what contractual obligations there are. It's also important to consider whether those particular obligations only apply during employment or whether you have obligations extending beyond employment as well. In terms of the position during employment, nowadays most contracts of employment, but not all, will have an express term restricting the use of confidential information during the term of that employment. And that term, as Katie mentioned, will usually define what's classified as confidential information by the employer. It will usually do that on quite a broad basis so that the employer can try to protect as much information as possible. And that term will go on to say the employee can't use that information during their employment other than in the proper course of their duties. So they can't use it for their own benefit or the benefit of any third party, only for the benefit of their employer. Now, even if there is no express term in the contract, though, which, as I said, is perhaps more unusual these days, but does happen, employers are still protected by an implied term of confidentiality, which arises as part of the wider implied duty of fidelity. And this means that during their employment, the employee cannot misuse confidential information. There's also, it's worth noting, something called an equitable duty of confidence. Now, that arises not technically as a matter of a contract between the employer and the employee, but simply because the employer gives their confidential information to the employee. And when that happens, that gives rise to this equitable duty of confidence that the employee cannot misuse that information. The position after an employee's employment has ended gets a bit more complicated. And the question of whether contractual obligations can prevent an employee from misusing information starts to depend on what the type of information was and what that specific information was. As Katie's mentioned, in the Facenda chicken case, the court drew a line between different types of information, and in particular between trade secrets, and that's really the sort of crown jewels, most important confidential information the business has, and what's deemed as mere confidential information. So it's still confidential, but it's less highly sensitive than trade secrets. And essentially, the position is that after employment, an employer can't stop an employee using that mere confidential information, but they can still stop them using trade secrets. The difficulty is that in practice, it can be really hard to identify the difference between what's a trade secret and what was mere confidential information. Now, trade secrets are protected after employment by the equitable duty of confidence, as well as that duty applying during employment. So employers will always be able to protect trade secrets after employment has ended. But if an employer wants to try and protect more than just trade secrets, or put another way to broaden the category of what might be classified as a trade secret, they can use an express term of the contract to try and do that. So employment contracts often contain an express term saying not only can employees not use information during employment, but they can't use it after their employment has ended as well. And what the benefit of having a clause like that is that you might be able to broaden that category of information which is protected after employment ends. Having said that, because such a clause applies post-termination, it will also have to be justified as any other post-termination restrictive covenant would be. But from an employer's perspective, it's always good practice to include an express term of confidence which applies after employment has ended to give yourself as much protection as you possibly can for your confidential information.
Thank you. So the next thing we move on to discuss is what can you do, or what should you do if you discover an ex-employee has misused confidential information? In summary, the process will normally be as follows. First, you identify that there's a duty. Secondly, you need to check that that duty has been breached, and then you need to obtain evidence to show that. Now, usually you'll put the employee or the ex-employee on notice of this fact, and you tend to seek undertakings from them that they will comply with any express or implied obligations they're bound by. If this request is refused, or if contractual undertakings are offered or deemed to be unsatisfactory, you then would have to issue proceedings in the court seeking injunctive relief and/or damages.
Katie, could I just jump in there and note that you've referred to contractual undertakings and undertakings to the court, and it's right, isn't it, that whilst the remedy for breach of contractual undertakings would just be the same remedy you'd get for a breach of contract, so essentially damages, if you breach undertakings given to the court, they have a bit more bite, don't they?
Yes, the undertakings to a court tend to have what's called a penal notice on them. And a penal notice is a warning to the defendant, say the ex-employee, that if they breach this or they disobey this order, they may be punished. Now, generally that punishment is a fine, but a case that I've been involved in, luckily it wasn't my client, but it was one of the other defendants who breached a penal order, was actually put in prison. Now, including a penal notice is standard when undertakings are given to the court. I have seen a case where someone tried to argue that the undertaking should be given to the court without including a penal notice, but that really is an anomaly. So we have the two types of undertakings. The first is just contractual undertakings, and the advantage of this approach is that it puts a line in the sand and discourages ex-employees who may not be willing to engage in a full-scale legal battle. So you may get to deal with a problem very quickly and quite swiftly. If the ex-employee fails to give the undertaking, it may indicate bad faith and possibly an intention that they're going to misuse the information. It's also likely, although not certain, that a court will look more favourably on a party that's made a genuine attempt to settle matters before issuing proceedings. And of course, if this approach is successful, there'll be a huge saving in terms of legal costs and avoid the need to produce lengthy witness statements describing in detail the confidential information that is being tried to keep secret. The problem with contractual undertakings is that they're no more enforceable than the original confidentiality obligation that the ex-employee has already breached. Essentially, the introduction of a contractual undertaking doesn't get the employer any closer to a court order in its favour. There's also the possibility of seeking undertakings from a third party that they know or believe to be in possession of their confidential information. So, for example, the ex-employee's new employer. Now, there's some tactical advantages to this as well. As the new employee will have only just started there, it doesn't set off the employment relationship with his new employer on a great foot. It makes them think they've got a wrong one, and it also sets up a claim against the new employer for potentially inducing that employee to breach their contract. And the benefit of having a new employer and not just an individual on the ticket of any claim is that it's likely the new employer is going to have deeper pockets. So what if undertakings, either contractual or undertakings to the court, don't work? If the parties are unable to resolve the matter through undertakings, then it may be necessary to issue a claim and file certain documents with the court and then serve them upon the ex-employee. This is what's called generally an interim injunction order. And this is a sort of holding measure to preserve the ex-employer's position by restraining the ex-employee from doing or continuing to do a particular act. Even the speediest of court proceedings can take weeks to reach a trial, by which time all of the damage may have been done. The confidential information that the ex-employer is seeking to protect may already be in the public domain, or it could have been used to the ex-employee's or the new employer's advantage. And in these circumstances, the ex-employer will need immediate protection for its business, and an injunction is the mechanism that provides that type of protection. Where employees have used their former employer's confidential information to their own advantage and have gained a head start in competition with their former employer, the court may grant a special type of injunction. This special type of injunction is called a springboard injunction, and this prevents them from taking advantage, an unfair advantage, of the head start that information has given to them. This type of injunction is usually necessary when an ordinary confidential information injunction is just not going to suffice, and that's because the information is no longer confidential as it's already been published, and therefore it's available for others to use. The type of situation where a springboard injunction may be appropriate is where someone has emailed lots of spreadsheets of renewal dates to their personal email address, and they're now using it their new employer, and the new employer has taken the business from the old employer already.
Thanks, Katie. As Katie has said, typically in confidential information cases, the primary remedy that a claimant would be looking at is an injunction, because what you want to do is either stop any damage to your business happening or stop further damage to your business happening. So quite often in these types of cases, at the time you find out about the misuse, you haven't actually suffered any financial loss at that point. And if you're lucky, you may be able to stop it by getting an injunction. However, if there has already been some financial loss and you think that there might be more, then your primary remedy would normally be a claim for damages for breach of contract. And obviously that's a financial remedy, putting you in the position you would have been in if that information hadn't been misused. Now, in other cases, there can be another type of financial remedy available, and that's called an account of profits. An account of profits isn't a remedy for breach of contract, but rather it's a remedy where there's been a breach of equitable obligations. And I spoke earlier about the equitable duty of confidence, which arises in all cases where an employer has given their employee confidential information. And where that's been breached, which it will have been if confidential information has been misused, there's the option of claiming an account of profits as an alternative to a claim for damages. And what an account of profits does is, rather than looking at what the claimant company has lost financially, it looks at what the wrongdoer, so the person who's taken and used your confidential information, what they've gained from doing that. And if the wrongdoer has made some financial gain out of using your confidential information, then if an account of profits is ordered, essentially they have to hand over to you the profits that they've made. Now, it's important to recognise that damages and an account of profits, it's a one or other situation. You can't get both, and you have to make what's called an election between which one you want to pursue. But you don't tend to do that at the start of a case. It's something that happens later when you've got more information about what's happened since your information was taken and misused, and typically after disclosure. But it's a useful way of making sure that you don't end up in a situation where information has been misused. It's difficult to prove exactly what loss that has caused to your business, but the wrongdoer has ended up with a windfall anyway. Katie, I think we're over to practical steps now, sorry, which is an area which I'm going to cover now, which is practical steps that you can take to cover or to protect your confidential information as an employer. Now, if you think back to what Katie said earlier about how the court identifies what information is confidential and what isn't, that includes things like how that information was treated by an employer, whether it was made clear to the employee that it was confidential, and there are some practical steps that employers can and should take to help themselves in the case that it comes down the line to having to argue about these things. So first and foremost, seems simple, but it's a really important step. Make sure you mark any sensitive information as confidential on the face of the document. So put it in big bold letters at the top of the document, confidential, so that it's clear from the face of it that that's the position. Also think carefully about who has access to sensitive information, and make sure it's restricted only to the people who actually need to see it to perform their job. So make sure that when you're managing your document storage systems, whether that's physical or most likely nowadays online, that sensitive information is kept separately from other less sensitive or non-sensitive information. So keep them in separate folders, separate places in your document storage systems, and where you have that sensitive information, protect it by measures such as password protection, and make sure that the only people who have those passwords and can access it are the people who really need to. Similarly, if you need to circulate that information, so you're emailing it to certain people, only email it to the people who need to see it, and make sure that it's clear on the face of that email that it shouldn't be circulated more broadly. Another important thing to think about is remote access to documents, and this is something I'll come back to touch on a bit later. But nowadays, and particularly, of course, as a result of the pandemic, people are working remotely and needing to access document storage remotely. Make sure that those systems are as seamless and as stable as possible, so that there's no excuse for employees to say that they need to take take documents offline and outside those systems, for example, by emailing them to their personal email accounts. You want to make sure that everything is kept within your systems. And taking a step back and thinking about what I've just said, what you're really aiming for as an employer is to stop an employee being able to argue that they didn't know something was confidential. You want to be able to say, look at what we did. It's obvious these documents were confidential. Now, as well as taking the sorts of steps I've just talked about in order to designate information as confidential, you also, as an employer, want to put yourself in a position where you can monitor what employees are doing with your information. And typically that's going to mean being able to monitor how they're using emails and your documents, and also potentially how they're using company equipment like a company laptop or a company mobile phone. Now, Katie's going to come on in a moment to talk about specific things that you should be monitoring in terms of suspicious activity. Just one point I'd like to make before she goes on to that is that you need to be careful when it comes to monitoring, that you do it in a way where an employee can't argue that you've breached their contract, usually the implied term of trust and confidence. And the way to do that is to make sure that your policies and potentially their contract as well covers the position in terms of monitoring, and just makes it clear that you have the right to access and monitor their use of your systems, including email, where you have reason to do so. Katie, as I said, I think you're going to talk now about monitoring behaviours.
Yes, so employers should be aware of behaviour that indicates that employees may be misusing or considering misusing confidential information. There are a couple of things that I think employers should look out for. So the first is working hours. If you notice that an employee is working outside their normal working hours, for example, working late at night, particularly if they're working unusual hours just before their employment terminates, when this is not their usual practice, it may explain that there's something not quite right going on. If there's an unusual amount of photocopying being done, that might lead to suspicions being raised. A case that I've done before came to light that someone had taken a whole heap of information because they had to enter their initials and a code into the copier before they were actually able to collect their printing. And because there was such volume being printed by this person, it raised flags, and they were able to detect what was being printed and what that employee was doing. There's also been cases I've seen where requests have been made to secretaries or more junior members of the team to put together business information, for example, lists of customers, without an obvious business reason being in place. If there's unusual periods out of the office, that might lead to suspicions that things have been, confidential information has been misused. If an employee is working on projects or maintaining regular contact with customers without their line manager's knowledge, that's another thing to look out for. The most common one is that where an employee has made extensive use of their personal email accounts by emailing documents to their personal email address. One of the biggest cases I've worked on came to light because an employee forwarded 33 emails to her personal email address, and those 33 emails had about 100 spreadsheets attached to them. And in the spreadsheets, they had customer names, addresses, telephone numbers and email addresses, and most crucially, their renewal dates. This was an insurance matter, and also the premiums that they paid on previous years. Now, that information is obviously confidential because it would allow them, their new employer, to know when to contact those clients, when to contact them, how to contact them, and also the point to pitch any kind of product, because they know what they paid last year. Another thing to monitor is the use of memory cards or USB sticks being put into work machines in case information is being taken that way, and whether documents are being taken, whether hard copy or electronically, out of employers' premises without authorization. Now, of course, employers have to have proper systems to ensure that these kind of behaviours are not missed. If businesses use security cameras anywhere on their premises, these will need to be reviewed. And the same goes for all email traffic. Now, it may not be necessary to have to read the emails themselves. As I mentioned a few moments ago, sometimes the volume of email traffic is enough to set a flag going. Many modern offices use entry systems who show who's entered the building and when they entered, and this is useful data if documents go missing around the time of an employee's departure from the employer. Lottie, over to you.
Thanks, Katie. So yeah, Katie's just talked about some of the things you should be looking out for. What happens when you do find that an employee has, for example, emailed loads of sensitive documents to themselves, and you confront the employee about that? Well, there's a number of you might call them explanations, you might call them excuses, depending on which side of the line you're standing on. But a number of things that employees usually say in order to explain what they've done. The most common explanations which come up tend to be one which I alluded to earlier, employees saying, oh, I needed these documents on my personal email address so I could work on them at home, or I needed to be able to print them at home, for example, that sort of thing. Or maybe I didn't realise that I couldn't take this document. I thought it was something I could use in my future employment. Now, the question for employers, obviously, is, will do those explanations get the employee off the hook, and what would a court make of them? In terms of employees saying, well, I needed to email it to my personal account so I could work on it at home, whether that's credible or not will typically depend on how good your remote working systems are, in the sense of, is it a valid excuse for them to say, I couldn't work on it through the remote working system? And the stronger your remote working system is, the harder it is for employees to make that excuse. And that's why, as I said earlier, it's so important to make sure these things are well set up at the outset. Also, you need to think about, well, does that explanation make sense in terms of the particular documents they've emailed to themselves, the number of documents, the contents of them, and the timing of it? It may be that they've emailed, as in Katie's case, such a huge number of documents to themselves just before they've left employment that their explanation simply isn't credible. In terms of the employees who say, oh, I thought it was okay for me to take that, well, that's going to come back to the question we talked about earlier of what you can do to make sure that an employee can't say, I thought it was okay to take it. And that's things like making sure the document's marked as confidential, restricting access, etc. And the more you've done that, the much harder it's going to be for an employee to make that excuse. The other justifications that often come up in these types of cases are those set out on the slide. So sometimes you get employees saying that there was a public interest in them taking and using this confidential information, which outweighs the employer's interest in the confidentiality of that information. Now, in the employment sphere, typically that arises in cases where there's an allegation of whistleblowing or an overlap with whistleblowing, and an employee who's saying, I needed that information to blow the whistle. Where an employee can show that they meet the criteria for whistleblowing under the employment legislation, so they had a reasonable belief that that information tended to show one or more of the prohibited things, so breach of a legal obligation, etc., and they can show that they thought that disclosure was in the public interest, then that can give rise to a valid defence to a breach of confidence claim, because you can't contract out of whistleblowing rights. Having said that, you'll know that under the whistleblowing legislation, there's a pretty strict regime as to how and who you can make whistleblowing disclosures to, and it's a fairly limited group of people. So, for instance, if you have made those disclosures to a new employer and a competitor of your old employer, that's very unlikely to amount to a protected disclosure for the purposes of the legislation, and therefore unlikely to be a defence to a breach of confidence claim. The other thing which arises fairly often is an employee taking information before they leave employment because they think they might want to use it against the employer in a claim that they have in mind. So, for instance, an employee is thinking of bringing a constructive dismissal claim, and before they resign, they start stockpiling the information that they think will help them in that case, and they do that by emailing it to themselves, etc. Now, employees often seem to think that that's okay, and it's okay for them to do that because they don't trust the employer to give them that information as part of the normal litigation process when they bring their claim. But the courts have been pretty clear that that's not acceptable, and that's not the way employees should go about bringing such claims. And rather than taking the information themselves on a unilateral basis, what they should do is bring their claim and wait for disclosure in the ordinary way. So that won't be a defence to a breach of confidence claim. Katie, we've covered quite a lot there. I think we're now at the stage where we share a few war stories about our experience of these types of cases in practice. And one thing that springs to mind to me is that I think we've both, I know we've discussed this before, we're amazed at how naive lots of employees are at thinking they can, for instance, email documents to personal accounts and that it won't ever be picked up on. And that's something we see a lot, isn't it?
I think people think they can get away with it. It gets more and more challenging when employers have better IT systems that flag these kind of things. But no, I'm always a little bit incredulous when everything sort of comes to the light of day that people thought they could get away with it in the first place. I've had a case before where someone was about to resign and it later turned out a whole team was about to resign, and that person was suspended after we got the injunction, and we went into his office and there was a tote bag stuffed full of printouts of spreadsheets of client information and really confidential information belonging to them, the customer. And it was still whilst he was still an employee, and he was just ready to take it, resign and leave. I've also had ones where people have taken photographs of spreadsheets on the computer and WhatsApp them among groups as well. So it does come out, and people think
that's interesting you say that.
Getting around it, but it always comes out.
Yeah, I've had the WhatsApp thing come up in a recent case as well, because I think you find whilst there are lots of these naive employees, there are also much more sophisticated ones. And I find particularly in certain industries like banking, insurance perhaps, where perhaps they're a bit more familiar with things like team moves and the concept of sort of litigation around confidential information and people moving employment, they can be much more sophisticated in the way that they go about these things. So I had a case recently where there was no documents being emailed back and forth, but what the people had done, as you've just said, is that they had taken photos of confidential information shown on their computer screen and then WhatsApp them between each other. And when a WhatsApp is deleted, it can be very hard to trace that. And what's more, the employee in this case, they were working remotely because this was during the pandemic. They'd logged out of their remote systems so that the computer was offline, and they'd thought that that would mean the company wouldn't know what documents they were looking at. So in these types of cases, it can be much harder to trace what's happened. But if you're good at your detective work, it still can be traced. So it's a bit harder to get that smoking gun, but you can get there. So for instance, in that case, the employee was wrong to think that when he logged off the system, it wasn't recorded. It was still recorded. And the fact that he'd logged off and then looked at these particular documents raised a suspicious activity flag, which meant the employer then had a sort of starting point. They pulled him in for an interview, and eventually he sort of cracked and told them what had happened. And that was the start of these proceedings. So as I said, sometimes you've got to work a bit harder and do your detective work, but usually there is a way, isn't there, Katie, a weak link where something comes out and that's the start of it.
Yeah, I've had one of my favorite weak links was a very clever insurance broker, or so he thought, and he wasn't emailing it from his email account. What he was doing was scanning in from the work scanner and emailing to a separate email address. So it wasn't logged on his personal email account, it was logged on the photocopier, and suddenly they looked at the photocopier logs and saw it was all going to a Hotmail account that wasn't to a client, it was just to a rather amusing Hotmail email address. And he thought he was going totally undetected. And I think he'd scanned something like 50 different documents, all containing super confidential information about a product that was about to launch. So yes, employees think they can get away with it, but more often than not, something or someone will trip them up.
Yeah, absolutely.
I think that's all we have time for now. So I will just finish up by saying thank you for listening all the way to the end. A special thank you to Charlotte as well for taking time to speak with me today. If you have any questions, you should be able to find an email address on the webinar page, and we'd be delighted to deal with them. Until next time, goodbye.
Thank you.